All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition of 2017, the English version. Please be seated.
Good afternoon, everyone. I would like to greet the teams for the defense, the teams for the Office of the Prosecution, and the team for the legal representative for the victims. Of course, I would like to welcome those who are in the public gallery, who are here to support the respective teams, and also the court staff and the interpreters, no, there aren't any interpreters this morning, who are diligently going to help us with our work. I would like to now turn to the court officer and ask that she call the case, please.
My apologies, my microphone. Thank you. We are sitting in an appeals hearing regarding the situation in the state of Valeria, the ICC Moot Court Competition 2017, the English edition.
Thank you. Now, on behalf of the chamber, I would like the respective parties and the participants to introduce themselves, and I'll begin with counsel for the defense. So please introduce yourself for the record.
Mr. President, Your Honours, may it please the Court, my name is Stephen Greatly Hirsch, and I appear today with my learned colleague, Miss Lena Ellen Becker, representing defence.
Thank you. The OTP.
Mr. President, Your Honours, may it please the Court, my name is Samson Lim, and together with the assistance of my co-counsel, Ms. Ng Pei Chi, we represent the Office of the Prosecutor.
Thank you. And the legal representative for the victims.
Mr. President, Your Honours, may it please the Court, my name is Bianca Stringer, and I'll be delivering primary submissions, and together with my learned colleague, Mr. Ryan Sheldrake, who will be providing the rebuttal, we have been appointed pursuant to this court statute to represent the victims, the Videsh, in this matter. May it please the Court.
Thank you. Well, thank you. I'd like to now just introduce the bench. On my right is Mr. Judge Hirad Abtahi, and on my left is William St. Michel. I am Judge Jeffrey Henderson, and I'll be presiding today. Now, the chamber will now proceed consecutively to hear the issues that shape the subject matter of today's proceedings. And mindful of the public nature of these hearings, I will ask the court officer to read the agenda.
Thank you, Mr. President. This case arises out of allegations of genocide and crimes against humanity committed in the territory of Valeria by members of a militant group known as the Dothraki Riders, including Mr. Tyrion Bannister. The state of Valeria and its neighbor to the south, the state of Quirth, are parties to several international instruments relevant to this case. On the 29th of January 2016, the commander of the National Army of Valeria, purportedly acting as head of the interim government for the country, filed a declaration accepting the jurisdiction of the ICC over international crimes committed in Valeria against the Verdash people between the 4th of December 2015 and the 25th of January 2016. On the 15th of March 2016, pursuant to Article 57 of the ICC statute, the ICC pre-trial chamber authorized an investigation into the crimes committed in Valeria against the Verdash people. On the 2nd of July 2016, pursuant to Article 58, the ICC issued a warrant for the arrest on charges of genocide and crimes against humanity of Tyrion Bannister. On the 5th of July 2016, shortly after Quith notified Valeria and the ICC that it had no intention of arresting any of the Dothraki riders or former Valerian officials who had taken refuge in its territory, the military government of Valeria sent a special forces unit to Quirth, which captured Tyrion Bannister. Since Valeria does not have a domestic law enabling it to prosecute the crime of genocide, on the 9th of July 2016, the interim government of Valeria turned Tyrion Bannister over to the ICC. In a written submission dated 24th of July 2016, the Counsel for Tyrion Bannister raised several objections to the jurisdiction of the ICC and other related matters, which the pre-trial chamber agreed to consider at a hearing on the confirmation of charges under Article 61 of the Rome Statute. The prosecution and defense have stipulated that Tyrion Bannister was 18 years old at the time of the alleged acts. They further stipulate that Tyrion Bannister was kidnapped from a small village in southern Valeria by the Dothraki riders in 2006 when he was 8 years old and forced to serve as a child soldier. From age 8 to age 15, he was subject to forcible indoctrination, including through beatings and involuntary use of narcotic drugs. The prosecution and defense do not agree on the legal significance of these facts. On the 30th of August 2016, representatives of the ICC Office of the Prosecutor, the Counsel for Tyrion Bannister, and the legal representative for the victims submitted briefs and made oral presentations before the pre-trial chamber on the issues raised by the defense. The appeals chamber seeks submissions of all parties and participants on the issues raised before the pre-trial chamber, namely, whether a military regime that seized power in a coup and claims to be the interim government was competent to accept the jurisdiction of the ICC on behalf of the state of Valeria. Whether the alleged actions taken by the accused against the third gender people in Valeria could qualify as genocide, and whether an 18-year-old could be excluded from criminal responsibility due to his former status as an involuntary child soldier.
Thank you, Court Officer, who for the record is Ms. Salazai. I will now give the floor to the defense so that you may present your submissions and address us on those three issues that have just been identified.
Mr. President, Your Honours, good afternoon. The accused in this case, Tarian Bannister, is a young man who for most of his life has suffered tremendous harm, physically, mentally, and emotionally. Robbed of his childhood and his agency, he too is a victim, and as the accused in this case, we must give full voice to his fair trial rights. To this end, Defence Counsel invites this court to grant the interlocutory appeal on three grounds. Firstly, that the Larash military administration was not competent to accept this court's jurisdiction. Secondly, that the alleged conduct against the third gender people could not qualify as genocide. And thirdly, that Mr. Bannister's former experiences as a child soldier, properly considered, could exclude him from criminal responsibility. And Your Honours, proceeding with the first ground of appeal, namely that the Valerian military administration did not have competence to accept this court's jurisdiction, Defence Counsel makes three submissions. Firstly, that legitimacy, not effective control, is required to accept this court's jurisdiction. And secondly, that the Valerian military administration was not legitimate and therefore was not competent to accept this court's jurisdiction. And Your Honours, proceeding with the first submission, namely that of legitimacy. Legitimacy, Your Honours, derives from the sovereign right of states to choose their own system of governance, the cornerstone of international law. By ensuring that all entities accepting this court's jurisdiction lawfully exercise state powers, we respect this right and we uphold the rule of law. And this approach is born out of the practice of this court with respect to previous 12.3 declarations and is in fact reflective of emerging international custom on this matter. Declarations made by Côte d'Ivoire, Palestine, and Ukraine have all been accepted by this court, and this is because in each case the declaration was made by a legitimate government lawfully exercising state powers. And in spite of the fact that neither President Gbagbo nor later Ouattara in Côte d'Ivoire, nor President Abbas in Palestine in fact exercised effective control at the time of the declaration. In fact, Your Honours, only once has this court refused to accept a 12.3 declaration made by a legitimate government, namely that made by President Morsi in relation to Egypt. However, Your Honours, the Office of the Prosecutor's determination in this case was based explicitly partly on the fact that the UN Secretary-General had already decided to seat and thereby recognise a competing Egyptian military administration. And this was without a vote, Your Honours, because exceptionally there were no challenges raised to the credentials of this competing administration. We submit that this is clearly distinguishable from the present case, where following several objections at UN bodies, the UN Secretary-General has only provisionally seated this interim government. And so the norm, Your Honours, is thus to treat the legitimacy of governments as determinative in recognising competence to accept the court's jurisdiction. And in fact, recent activity of the United Nations illustrates the international community's position on this matter. It illustrates how they not only refuse to recognise but refuse to tolerate illegitimate governments, and they actively seek to restore power to legitimate leadership where it has been usurped. Following similar UN-backed interventions in Haiti and Sierra Leone, I would like to draw the court's attention to present-day activities in relation to Yemen, because this is particularly relevant, Your Honours. In this case, we have another self-proclaimed interim authority that has unlawfully seized control from a legitimate government and has dissolved parliament. And Your Honour, states have rejected this interim authority. Moreover, the Security Council maintains an ongoing regime of economic sanctions against the unlawful Houthi administration, while a US-led international coalition actively seeks to restore the elected President Hadi to power. Your Honours, in more explicit legal terms, states are even now seeking to prosecute illegitimate governments. And we can see this move towards criminalisation on a regional level. The African Union in 2014 voted to adopt the Malabo Protocol, which will add a criminal chamber to the African Court of Justice and Human Rights, specifically to hear international criminal law cases. And Your Honours will find at Article 28E of this protocol the new crime of unconstitutional change of government, which explicitly targets coups d'etat as well as putschs and juntas. Now, Your Honours, having established that legitimacy is in fact required to accept jurisdiction, we submit that the Valerian military administration is not legitimate. This administration seized power in a coup d'etat. This was in clear violation of the established system of democratic governance. And in fact, this administration created the very power vacuum it now seeks to fill, supposedly by exercising effective control, ousting the chosen leadership of the Valerian people. And, Your Honours, despite proclaiming itself an interim government, there are no signs of any preparations to hold democratic elections, not at the time of filing, not almost 18 months after this declaration, Your Honours. And not only is this administration illegitimate, Your Honours, nor is it widely recognised by the international community. In addition to the several objections lodged at United Nations bodies, 30 states have formally denounced the coup d'etat and severed trade relations with Valeria until such time as the democratically elected, legitimate government is restored to power. And so, Your Honours, in any case, accepting this 12-3 declaration at this point would be premature because it would preempt the results of Valerian elections. It would preclude the United Nations from returning a definitive decision on the matter. And crucially, Your Honours, it would legitimise an unlawful administration with no respect for the rule of law. This would incentivise future coups d'etat, destabilise Valeria, if not the region. And if I might conclude Defence Counsel's submissions on this issue, the Court's previous practice has viewed legitimacy as determinative. And there is no reason to depart from this, particularly where it begins to converge with emerging international custom. Legitimate governments exercise control over the hearts and minds of the populations they seek to represent, not simply the territories they claim to administer. This administration is not legitimate, it is not competent, and as such, this Court does not have jurisdiction over the case, Your Honours. And so thank you, Your Honour. To proceed to the second ground certified for appeal.
Before you proceed to your second ground, I would just like to ask some clarification. In your view, are all democratically elected governments legitimate?
I'm grateful for Your Honour's question. It is not submitted that all democratically elected governments are necessarily legitimate. It is submitted that governments are legitimate where the means by which they ascend to power are lawful, are constitutional, are adherent to the country's particular framework. That this may be democratic, this may not. Your Honours, in relation to the second ground and the qualification of the alleged conduct of genocide, defence also has two submissions to make. Firstly, that the pre-trial chamber erred, relying on the stable and permanent criterion, an incorrect legal basis on which to consider groups protected from genocide. And secondly, that the third gender people of Valeria are not a protected group under Article 6 of the Rome Statute. Now, addressing the stable and permanent criterion, Your Honours, this was in fact the sole basis identified by pre-trial chamber 6 in the confirmation of charges hearing at paragraph 9 to qualify the alleged conduct as genocide. Now, Your Honours will no doubt be aware that this is not an element of the crime, nor is it listed anywhere in the Rome Statute. In fact, Your Honours, this criterion arose in the trial chamber decision in Akayesu before the ICTR, and is therefore not binding on this court. Moreover, it was never explicitly applied in later cases. And crucially, to apply this criterion, Your Honours, would breach the principle of legality by which this court is bound, enshrined under Article 22(2) of the court statute, which explicitly calls for a strict construction of the elements or the definitions of crime. Now, the ordinary language of Article 6 is clear and unequivocal. It provides an exhaustive list of 4 categories of protected group: national, racial, religious, and ethnical, which in any case must be targeted as such. Thus, Your Honours, the stable and permanent criterion in any case per se would not suffice to consider a group protected. And to address the protected groups, Your Honour, specifically ethnic groups, as my learned friends for the prosecution and the Victims' Council have suggested that the Verdash could qualify as an ethnic group. Through the case law of the ad hoc tribunals, various approaches have developed to characterise the 4 categories of protected group under Article 6, in order to determine whether any individual group could fall within these categories. These approaches include examining the objective characteristics of the groups in question, the subjective perceptions of these groups, or a combination of the two. The pre-trial chamber in the al-Bashir arrest warrant case of this court noted that this court as yet has not expressed any preference for a particular approach. However, on any approach, the third gender people do not qualify as an ethnic group. Defence counsel particularly advocates the adoption of a mixed approach, as outlined in the trial chamber case of Kirstich before the ICTY. On an objective approach, Your Honours, to group characterisation, the Akayesu trial chamber at paragraph 513 introduced the requirements of common language and culture, while the al-Bashir chamber at paragraph 137 reaffirmed these criteria, making them cumulative and adding the requirement of specific tribal links to the land. Your Honours, we know from paragraph 4 of the International Rights Watch report that the third gender people are all born into two existing ethnic groups in Valeria, the Lorash and the Steelborn, and there is nothing to suggest that at any point they shed this label or they leave this group. The third gender people exhibit no specific ties to the land. In fact, they are a nomadic people, nor are they united. They live in dispersed camps, and in fact, not all individuals choose to join their local community. Defence counsel acknowledges that the third gender have developed a distinct dialect and custom and clothing. However, Your Honours, it is submitted that this is not what unites the group. This is not their defining characteristic. It's rather an expression of the group identity assumed upon joining the group, typically at puberty. This is in fact a gender identity, Your Honours, and it is submitted that the third gender people are exactly what their name indicates. This would be in line with the statute's consideration of what constitutes a gender, the international legal understanding of gender, and in fact the Yogyakarta principles adopted in 2007, Your Honours, which indicate that gender is primarily expressed through speech, mannerisms, and dress. Your Honours, there are no other contextual factors that could be used to characterise this group as an ethnicity, such as were present in the Rwandan genocide, where the trial chamber in Akayesu found that the fact that Hutus and Tutsis held identity cards administered by Belgian authorities to distinguish them was one such additional objective criterion. Now, if we move to the subjective approach, Your Honours, and we consider the perspectives of society, of the group itself, and the alleged perpetrators, we know from paragraph 2 of the IRW report that Valerian society recognises only two ethnic groups, and that all third gender individuals again are born into these groups. Instead, the third gender people have been, to quote paragraph 4, socially recognised as a unique gender in Valeria for hundreds of years, a perception supported by the group's self-identification at paragraph 3 as, and I quote, individual belonging to neither the female nor male genders, without reference to ethnicity, without distinction from Lorash or Steelborn. And Your Honours, there is no reason to believe that Mr. Bannister perceived the third gender people any differently from the rest of Valerian society. And combined with the group's own identity as a gender, and the objective ways in which the members express this gender identity, we submit that Tarian too could only have perceived this group as a distinct gender. And to conclude on this matter, Your Honours, only groups listed under Article 6 are protected from genocide, and they must be targeted as such. The third gender people do not qualify as an ethnicity. However, they do qualify as a gender. Gender is not listed under Article 6, Your Honours. Thus, there are no substantial grounds to believe that the third gender people are a protected group under Article 6. Therefore, the conduct against them cannot qualify as genocide, and this case must be dismissed. And if I proceed to the third ground for appeal, Your Honours, namely relating to the criminal responsibility of Mr. Bannister, the defence submits that there was a material error of law when the pre-trial chamber found that, pursuant to Article 26, Tarian's brutal childhood as a child soldier, quote, can have no effect on his culpability. Your Honours, this is plain error. Article 26 regulates jurisdiction, not culpability. It defies both common sense and law to say that his lifetime of victimisation could have no bearing on his culpability. The pre-trial chamber erred when it refused to recognise that Mr. Bannister could be excluded from criminal responsibility due to his horrific experiences as a victim, which the defence will show, if permitted, excludes him from criminal responsibility pursuant to Article 31. Your Honours, this legal error, conflating Article 26 with 31, is not only material, it strikes at the heart of the defence case. And to this end, the defence submits that Tarian is entitled to plead an individual offence, and that at the time of the alleged conduct, Mr. Bannister suffered from mental incapacity and that he acted under duress. Now, Your Honours, addressing the individual defence note, in accordance with the right of the general right to plead a defence enshrined under Article 67(1)(e) of this court statute, Articles 31(2) and 31(3) of the statute provide this court with considerable discretion. The former in determining the applicability of the 4 defences listed under Article 31(1) to the case before it, and the latter in accepting alternative defences. Thus, child soldier status, referring simply to the collection of experiences typically undergone by child soldiers, could exclude them from criminal responsibility on a case-by-case and not automatic basis, either by furthering pleas relating to the defences listed under Article 31(1), or in constituting an alternative defence under 31(3). And particularly with relation to Article 31(3), examples of concurrent or hybrid defences might see this court accept, for example, that mental impairment affects one's perception under duress, or that the constant exposure to threats impairs one's mental capacity to appreciate or control conduct. And the defence submits that the link between these defences in this case is provided by the process of Dothraki indoctrination, which uses the prolonged issuance of threats that materialise in order to instill a sense of hopelessness, fear, and ultimately blind obedience in the individual child soldiers, thereby removing free will and destroying capacity for independent thought. Now, on the mental incapacity note, Your Honours, in relation to Article 31(1)(a), this court has heard expert testimony in the Lubanga trial, echoed by then-prosecutor Ocampo, describing the particular susceptibility of child soldiers to mental conditions such as post-traumatic stress disorder and major depressive disorders, particularly where they were trained under a system of threat and punishment, as we know from the facts was the case for Mr. Bannister. Your Honours, together with the existing evidence established at paragraph 7 of the confirmation of charges hearing, defence submits that this court is free to make the logical inference that the prolonged and severe traumatisation suffered by Mr. Bannister during his childhood and his adolescence impeded his cognitive development and his maturation, and that aggravated by his extensive forcible use of narcotics, his lack of education, and his indoctrination with an alternative moral framework, this constituted a mental defect or abnormality of mind that destroyed his capacity both to formulate the requisite genocidal intent and to appreciate the unlawfulness of his conduct. Now, a note on the defence plea under Article 31(1)(d), Your Honours. Your Honours will be aware that there are 4 requirements for a defence plea, duress plea. The accused faces a threat of imminent death or serious bodily harm. He acts reasonably and necessarily to avoid said threat materialising, and his conduct seeks to avoid doing greater harm. We know from paragraph 7 of the confirmation of charges hearing that there were extreme conditions of survival for Mr. Bannister. He acted under a continuing threat of death presented by John Sleet and the Dothraki leadership. Mr. Bannister also acted reasonably and out of necessity, not as the reasonable hero or even as the reasonable man, but as the reasonable child soldier. This case is distinguishable from the Ongwen case, Your Honours, because the pre-trial chamber's reasons for denying Mr. Ongwen the defence in that case, at paragraphs 152 to 155 of the pre-trial chamber confirmation of charges hearing, do not apply here. Unlike Mr. Ongwen, Tarian occupied no formal leadership role within the Dothraki riders, nor did he have any real opportunity to escape. Nor did he commit any independent crimes or unnecessary crimes beyond his instructions from John Sleet. It's also worth noting, Your Honours, that he had not enjoyed a 20-year career with this military group. He thus cannot be said to have exercised choice, participated voluntarily, or shared Dothraki ideology. And finally, Your Honours, the proportionality requirement. I see my time has expired. Might I have a moment to briefly finish on this issue?
All right, the rules will permit you to have 1 more minute.
I'm grateful. The proportionality requirement is fulfilled inasmuch as Mr. Bannister believed that the third gender people would be killed and these attacks would take place whether he followed orders or not. But he also knew from experience that if he did not follow orders, he would be killed. He had seen it happen several times before. Thus, in seeking to preserve his own life, he simply sought to protect himself. He simply sought to avoid a situation in which there was one more body added to the pile of third gender victims, Your Honours. And this is supported by Judge Casasi's dissenting opinion in the Appeals Chamber ICTY case of Adamovich at paragraphs 44, where he conducts a survey of international law and finds that an exception is made where the individual in question's death or refusal to obey orders and commit the crime would have no material effect. Thus, Your Honours, the Defence Counsel invites this court to grant its appeal on the facts that the interim administration lacked competence to accept this jurisdiction because the alleged conduct... I'm out of time. I'm grateful.
Thank you. Thank you, Mr. Counsel for the defense. We will hear the counsel for the Office of the Prosecutor.
Mr. President, Your Honours, may it please the Court. My name is Samson Lim, and together with my co-counsel, Ms. Ng Pei Chi, we represent the Office of the Prosecution. Your Honours, this case arises out of the slaughter of more than 5,000 Vadash. This constitutes 2/3 of the Vadash population in Valeria. And these massacres were condoned by the former government of Valeria. Faced with such brutality, the military in Valeria has been forced to take steps to shield the very same citizens that the former government had failed to protect. Now, as part of this process, this court is now asked today to affirm the decision of the chamber below and confirm the charges against one of the key perpetrators of these massacres, one Mr. Tyrion Bannister. Now, the prosecution does recognize that there are complications regarding Mr. Bannister's status as a former child soldier. But, Your Honours, this court is not asked today to pronounce on Mr. Bannister's ultimate culpability, but only to decide if there is sufficient evidence to bring the case to a full trial. And therefore, Your Honours, given the grave harm and suffering that has been endured in Valeria, we submit that this court should not dismiss the charges at this stage of the proceedings. Instead, Your Honours, this case should proceed to trial and fulfill this court's mandate to end impunity for all mankind. Therefore, we make 3 submissions. First, that the interim government was competent to represent the state of Valeria. Second, that the alleged actions against the Vadash could constitute the crime of genocide. And third, that Mr. Bannister's former status as a child soldier does not exclude him from criminal responsibility at this stage of the proceedings. Your Honours, turning then to the first issue, the crux of the dispute is whether the interim government could validly represent the state of Valeria when it filed the Article 12.3 declaration. Now, we recognize that the interim government did not come into power in ideal circumstances. But, Your Honours, we would remind the court that before the military intervened, Vadash were being slaughtered in the thousands, a state of affairs that would have continued without the military's intervention. Moreover, Your Honours, this dispute does not turn on whether the interim government is ideal, but only on whether or not it was ineffective control. And we note that counsel for the defense disputes this. They argue that customary international law mandates that only a democratically legitimate government can represent Valeria. But, Your Honours, the difficulty is that democratic legitimacy as a test is wrong as a matter of authority and as a matter of principle. As a matter of authority, the 1923 Tinoco Concessions Arbitral Tribunal decision, the 2001 Fiji and Prashad decision, as well as the Office of the Prosecutor's statement on Egypt, all confirm that the applicable test is not democratic legitimacy, but that of effective control. Now we note counsel for the defense have relied on two primary authorities for the contrary proposition. They state the Office of the Prosecutor's determination in Palestine, as well as the Côte d'Ivoire authorization decision. Now on the Office of the Prosecutor's decision in Palestine, that decision concerned questions of statehood, which involves questions of state sovereignty, which is far removed from our present circumstances, which is a question on governmental competence. And therefore, the Office of the Prosecutor's determination is more relevant in this regard. Turning then to their reliance on the Côte d'Ivoire authorization decision, counsel for the defense have argued that because the democratically elected Ouattara government filed the 12-3 declaration, it proves that democratic legitimacy is the test. But Your Honours, their reliance is misconceived. Because the Ouattara government did not, in fact, file an Article 12.3 declaration. They merely sent letters confirming the previous Article 12.3 declaration made by the prior government that was still in force. In fact, the Chamber in its Côte d'Ivoire authorization decision specifically noted that Mr. Ouattara's capacity to bind the state of Côte d'Ivoire was not an issue. And this was stated at paragraph 66, and I quote, "The Chamber deems it unnecessary to address both the validity of the letters or the question of the capacity of Ouattara to bind the state," end quote. In fact, Your Honours, state practice contradicts the defense counsel's position that there is a test of democratic legitimacy. This can be seen by the reality of very recent situations in Egypt and Thailand, both states which had governments that came into power through undemocratic means, yet unquestionably represent their states. The authorities that have been cited and the state practice, the tenor of contemporary state practice, is underpinned by the principle that international law does not mandate any particular form of government. This is further supported by the diversity of non-democratic governments that do validly exist in our world today. Now, Your Honours, we recognize that it may seem troubling that the court is appearing to endorse an undemocratic regime, and this is precisely the defense counsel's suggestion. But this brings us to Your Honour's earlier concern and question towards the defense, where Your Honours asked, are all democratic governments legitimate? And this is precisely our point, because apart from the fact that the test of effective control is consistent with state practice, it can also be consistent with notions of policy and justice. Because the reality is there are situations where even democratic governments do terrible things to their own populations. And it may sometimes be necessary for another authority to stop the atrocities. And this was precisely the situation that confronted the international community with regard to the situation in Rwanda. There, the government of Paul Kagame came into power through military force, usurping the previous government. But despite the fact that this government did not hold elections from the period of 1994 to 2003, nevertheless, this government was regarded as competent to represent the state of Rwanda. Your Honours, therefore, in our submission, the test is not democratic legitimacy, but that of effective control. And this test of effective control comprises three elements. First, territorial control. Second, habitual obedience. And third, a reasonable expectancy of permanence. Your Honours, we note that at these oral proceedings, the Defence Counsel has not contested the existence of effective control, and therefore we will only briefly address this concern. These three requirements go towards showing whether a government is in fact able to control the state and its people, and we say here the facts in totality do suggest that effective control is made out. Specifically, at paragraph 8 to 10 of the NGO report, the military and police have all pledged allegiance to the interim government. There have been 1.5 years of peaceful administration since the time the military took power. And further, there are no competing authorities active in Valeria. Therefore, Your Honours, we will say effective control is made out. The interim government is competent to represent the state of Valeria, and therefore, we turn to issue 2. On issue 2, Your Honours, at the outset, we do recognise that the defence is not contesting the crimes against humanity jurisdiction of this court. Nevertheless, Your Honours, the prosecution desires the charge of genocide to be confirmed as well, because the crime of genocide does not only protect individuals from persecution, but was also formulated to specifically protect entire human groups from destruction. And here, Your Honours, the victims have witnessed the systematic slaughter of 70% of their fellow Verdash in a little over a month. It is a matter of great importance that this court record this event as a genocide for this court's historical record to provide closure for the surviving Verdash and protection from future attacks. Therefore, the crux of the issue is whether the Verdash can be protected under Article 6. Now, we submit that the Verdash are a protected group for two reasons. First, that the Verdash are an ethnic group, and second, and in the alternative, that they are a permanent and stable group. But for the purposes of these oral proceedings, we will focus on the argument of ethnicity. Your Honours, ethnicity is defined on the basis of shared cultural bonds, which can manifest through common cultural practices, such as a common language, set of customs, or lifestyle. Now, this was stated in the International Law Commission's 4th report on the draft Code of Offences against Peace and Security of Mankind. Counsel for the defence have argued that the Verdash are precluded from protection merely because they are a gender group. Your Honours, we do accept that the Verdash may indeed have a primary categorization as a gender group, but the difficulty is the mere fact that they are a gender group does not preclude them from protection as an ethnic group under Article 6. And we can see this in two ways. First, in the ICTY's Christic decision of 2001, there they held that the Bosnian Muslim group was both a national group and a religious group. And we say similar considerations apply here. It is possible to establish that the Verdash are not only a gender group, but also an ethnic group. And second, Your Honours, it is clear that the Verdash go beyond merely a gender group, and we can see this from page 6 of the pretrial chamber decision at paragraph 4, because there it states that it is often children who are determined to be third-gendered often get sent to the Verdash group. And this means, and this fact means, that not every Verdash, or rather not every third-gendered child gets sent into the Verdash community. And this suggests that entering into the Verdash community goes beyond gender. Entering into the Verdash community involves accepting a complicated set of cultural practices, clothing, lifestyle, and even a distinct dialect. And we note that very similar considerations were considered by this court in its Al-Bashir decision of 2009 to hold that the Fur, Masalit, and Zagawa groups were in fact ethnic groups. And in addition to this fact, we would also note that the Verdash have a shared history, 100-year history, more than 100 centuries-old history of persecution by the stillborn. And this shared history of persecution was deemed relevant by the UK House of Lords decision of Mandela Singh and Dao Lee in 1983 for them to hold that the Sikh ethnic group was in fact an ethnic group. And before we leave this point, we would draw one further comparison to the Sikh ethnic group, because there the court stated that the Sikh originally had, this Sikh ethnic group originally congregated on the basis of their religious identity. But because this ethnic group developed more cultural practices over centuries, they subsequently also developed the characteristics of an ethnic group. And we say here very similar considerations apply. The Verdash may have started out as a gender group, but eventually they developed these objective cultural indicators of ethnicity that warrants protection under Article 6 as an ethnic group. Your Honours, turning then to the third issue before this court.
Just a moment.
Thank you. When discussing the second point, you placed the emphasis on the group aspect of the chapeau of the genocide, definition of the crime of genocide. Assuming that that is correct, there is still the other part, which is the destruction and intention to destroy in whole or in part the group. I didn't hear much on this issue. Specifically, the only reference I heard from you was the systematic slaughter, I quote, hopefully correctly, of the Verdash. So I'd like you to explain what, if this is a group, if this group falls within the groups defined in the definition of genocide, what is your viewpoint and position on its destruction and intent to destroy it in whole or in part?
Your Honours, we do recognize that there is a specific intent requirement in order for the Article 6 protections to be engaged. And we say that Mr. Bannister did in fact have the specific intent to destroy the Verdash as a group. Now, we do acknowledge that it is not absolutely certain that Mr. Bannister did possess the specific intent. But at this stage of the proceedings, absolute certainty is not required. As clarified by this court's Al-Bashir 2010 decision, the court stated we can infer specific intent so long as the facts support an inference to the requisite standard of proof, which is here substantial grounds to believe. And Your Honours, here we can infer that there are substantial grounds to believe that Mr. Bannister did in fact share in the intent of the Dothraki riders to destroy the Verdash in whole or in part. At paragraph 7 of the NGO report, at page 7 of the pre-trial chamber's decision, we can see that the Dothraki riders, in a series of planned and coordinated attacks, wiped out more than 70% of the Verdash population in 6 weeks. They only targeted the Verdash. These were not one-off killings, but a series of coordinated massacres. And specifically to Mr. Bannister himself, he was a key element in these attacks. He rose to a position of leadership in a young age. He led repeated massacres which specifically targeted the Verdash. He killed hundreds in total. His raids were so infamous that they were specifically noted by the NGO as being particularly brutal. This suggests a degree of conviction satisfying the requirement of specific intent to the requisite standard of proof. Your Honours, turning then to the third issue. Now, counsel for the defense have suggested that the pre-trial chamber has made an error because the pre-trial chamber appeared to permanently foreclose the possibility of defenses. But Your Honours, we say that we need not take this interpretation of the pre-trial chamber's statements. The pre-trial chamber could very well was not, rather we can say that the pre-trial chamber was not foreclosing the possibility of the defense entirely. They were merely stating that the defense were not made out at this early stage of proceedings. Now, even if the pre-trial chamber, or rather even if this chamber is minded to take the defense's interpretation, we fully agree with the defense that it shouldn't preclude the defenses entirely. But this court can allow the appeal on the limited ground that this defense should not be excluded entirely and can be invoked at trial. The court can do this pursuant to Rule 158, Part 1 of the Rules of Procedure and Evidence. Now, engaging with the merits of the defense counsel's submissions on this point, counsel for the defense purports to invoke Article 31(3) of this court statute to import a defense protecting child soldiers for their indoctrination. Your Honours, there are two key barriers to this argument: procedural and legal. On the procedural point, the content of Article 31(3) is expressly prefaced with the words "at trial," which strongly suggests that Article 31(3) should only be invoked at trial. In fact, this was confirmed by the Dominic Ongwen decision at paragraph 151, where the court highlighted that while duress could be invoked at the pre-trial stage, Article 31(3) could not. In principle, the consideration of novel grounds for exclusion of responsibility is a complex issue, and this is precisely why the drafters of the Rome Statute pushed this determination to the trial phase. Moreover, even if we were to accept that Article 31(3) can be invoked, the defense has cited no legal authority for the basis of importing a defense into international criminal law. Your Honours, we do recognize that Mr. Bannister was indeed a victim, but Your Honours, it has never been the position of any international or municipal courts to exclude responsibility merely on the basis that Mr. Bannister was once a victim, or rather a perpetrator, like Mr. Bannister, was once a victim. This does not mean that this court cannot take into account Mr. Bannister's status in a principled manner, because this court can take into account his circumstances at the sentencing and mitigation phase of proceedings. Your Honours, turning then to the argument on duress, counsel for the duress relies on Article 31(1)(d) to assert that Mr. Bannister's conduct was caused by duress. But Your Honours, we will note at this stage of the proceedings, the burden is on the defence to adduce evidence, clear evidence, and I quote the Ongwen decision at paragraph 151, the defence must adduce evidence so clear that it negates the low evidentiary standard applicable, end quote. This high standard is consistent with the fact that counsel for the defence is essentially urging this court to dismiss the charges outright at the pre-trial stage. Your Honours, the prosecution is not foreclosing the possibility that duress can be made out at trial. But at this stage of the proceedings, we say there is insufficient evidence to dismiss the charges entirely. Your Honours, given the diminishing time, we will only address one element in duress, the first one, on whether or not the threat has the requisite degree of imminence. Your Honours, at this point, we will note that the Ongwen decision at paragraph 153 noted that membership in an organization with harsh disciplinary measures is not sufficient to make out a relevant threat. There needs to be direct evidence of a threat operating on the individual at the relevant time. The rationale for this is that otherwise, members in such organizations would have a blank check to commit crimes with impunity. Therefore, direct evidence that Mr. Bannister was operating under a threat at the age of 18 is lacking. In fact, there are two facts which cast serious doubt as to whether duress should apply. First, Mr. Bannister was the leader of a raiding party, which suggests a degree of agency inconsistent with this theory of duress. And second, from page 8, paragraph 7 of the pretrial chamber's decision, there was a 3-year gap between the end of his indoctrination and the time he committed the massacres. Your Honours, if I may have 1 minute to summarize my point.
Yes, the rules permit you to be granted at 1 minute. Proceed.
Much obliged, Your Honours. Your Honours, this 3-year gap raises the possibility that it was no longer a threat that motivated him to commit the massacres, but rather he was instead acting on his own convictions and beliefs. Your Honours, the larger point to be made here is that we do acknowledge there is considerable uncertainty on both sides. However, in deciding how to resolve this uncertainty, this court should have regard to the consequences of holding one way or the other. If the defenses are made out and the charges are dismissed, the chance for the victims to hold Mr. Bannister accountable will be foreclosed forever. If instead the charges are confirmed, Mr. Bannister can still avail himself of the defenses at the trial stage. For this reason, we submit that committing these proceedings to trial will ensure both substantive justice for the victims of these massacres and procedural justice for Mr. Bannister. Your Honours, I have come to the end of my submissions, unless I may be of further assistance.
No, thank you very much.
Thank you, Your Honours.
Right, so we will hear from the legal representative to the victims. There was an area which I would like to hear you on sometime during the course of your submission, which I'm sure you would address, which has to do with the test that the pretrial chamber applied when they considered the issue of victims.
Sorry, Your Honour, could you please repeat the question?
Yes, if you can, I wish to hear you on whether the pretrial chamber considered the appropriate legal test when they were considering who was the actual group of victims. You with me?
Certainly, Your Honour, yes. Mr. President, Your Honours, may it please the court. The dead cannot speak of the injustices visited upon them. It is my duty to ensure that their voices are heard. The Vidaish have been subjected to genocide. 5,000, which is 70% of the Vidaish population, have been exterminated. The Vidaish have been denied the most basic of human rights, the right to life, and as such are owed justice in response to this most heinous crime. The International Criminal Court is a court of last resort and it has a duty to end impunity. As victims' representative, we'll be making 3 submissions in response to the defence appeal. That firstly, on the 15th of September 2016, the pre-trial chamber correctly determined that the Videsh are a distinct, stable and permanent group. Genocide is therefore the correct charge, and Mr. Tarian Bannister must stand trial. Secondly, that the chamber did not err when it determined that Bannister's former status as an involuntary child soldier could have no effect on his culpability for the international criminal acts undertaken as an 18-year-old. And finally, that this court correctly determined it has the necessary jurisdiction to consider this matter. Turning to our first submission with respect to the stable and permanent characteristics and the finding of genocide. In this submission, we'll be making a response to the defence submission with respect to Article 22. I'll be addressing the question submitted to the prosecution with respect to intent. I will then address that the Videsh are an ethnic group before turning to the stable and permanent characteristics. With respect to Article 22, we are not asking this court to expand the definition of Article 6. It is our submission that the Videsh do fall within one of the 4 protected groups, being that of national, racial, religious or ethnic. In fact, the Videsh are an ethnic group. We accept that the Article 6 must be applied strictly. However, the Videsh are an ethnic group. With respect to the question of intent submitted to the prosecution, we disagree that there is sufficient evidence to demonstrate Bannister's intent. However, if I may direct your Honour's attention to the Christich appeal before the ICTY heard in April 2004, it was held there that intent is linked to aiding and abetting the crime of genocide. And Mr. Bannister is on trial for aiding and abetting the crime. And to attach the crime of genocide to an individual, the individual only needs to possess knowledge of the principal perpetrator's intent, and that Mr. Bannister did not need to have his own specific intent to commit genocide. It is our submission that given his indoctrination and time with the Dothraki riders, Mr. Bannister would have been aware of John Sleet's genocidal intent. Furthermore, again from the same case in Christich, conduct is sufficient for intent to be established. It is our submission that the matter must proceed to trial where it can be appropriately considered. Turning to our primary submission with respect to ethnicity. In 1948, when the United Nations General Assembly drafted the Genocide Convention, it chose those 4 specific groups, as members of these groups were traditionally the target of animosity. Furthermore, the groups displayed common characteristics, being that of homogeneity, cohesiveness, stability, and tradition. We accept there is a gap in the law in that an ethnic group is not defined by the Rome Statute, the elements of crime, or the rules of procedure and evidence. As such, pursuant to Article 21, 1b through to c, this court is permitted to turn to jurisprudence of other courts in order to consider an ethnic group. In the 1998 trial judgment of Akiyasu, the ICTR considered that an ethnic group was one, and from paragraph 513, generally shares common culture or language. This is not definitive. In here, we have common culture and language. With respect to the Videsh, at paragraph 4 of the International Rights Watch report, it outlines that the Videsh share particular cultural customs and distinct clothing, and we accept that this may not be sufficient evidence to be fully satisfied of common culture. However, when the Videsh identify as belonging, when a person identifies that they are third gender and therefore belong to the Videsh community, by joining that community would be evidence of culture. With respect to language, we accept that the Videsh speak with a heavy accented dialect of the Valerian language. We also accept that a dialect may not necessarily rise to the level of a language. However, it is a distinguishing feature for the Videsh. Only the Videsh speak with this heavy accented dialect. Defence counsel also raised a further indicia, being that of links to the land, which comes from the 2009 arrest warrant decision 1 before this court in Al-Bashir. Defence counsel also submitted that there was no evidence of links to the land. However, the Videsh have been likened to the Roma community, which is a nomadic lifestyle. And just because a community is nomadic does not mean that they don't have sufficient traditional links to the land. I give 2 examples here. Some of the Roma are known for going and working on farms during the summertime and then coming back to more permanent housing in winter. But I'd also like to draw your honour's attention to the Indigenous Australians. Traditionally and historically, Indigenous Australians have not remained within one place. They have a nomadic, or did have a nomadic lifestyle, where they worked the land in harmony with their surrounding lifestyle. And the Indigenous Australians sought to move on from their current place to allow land to regenerate and regrow. We submit there's insufficient evidence to currently before the court that the Videsh do not have traditional links to the land, and a nomadic lifestyle could be considered traditional links to the land. In, again, the 1998 trial judgment in Akiyazu, the ICTR had the difficulty task of determining whether or not the Tutsis were an ethnic group, as it was found that the Hutus and the Tutsis shared same common language and culture. In the 1999 trial judgment, again before the ICTR, in the case of Kayashima, it was also considered in that case that common language and culture are one of the indicia for ethnicity, as well as identification by members of that group themselves or by others, thereby providing subjective criterion. In the, again, 2009 Al-Bashir arrest warrant decision 1, at paragraph 137, but reference to footnote 152, the court held that as there is no definition of an ethnic group in international law, it is unclear whether the indicia should be wholly subjective, wholly objective, or a combination of both. And in that case, the majority opinion did not need to determine ethnicity any further, as it was clear that the groups in that case were an ethnic group. However, it is our submission that the court should apply a combined approach of objective and subjective criterion, which I will now turn to with respect to the stable and permanent characteristics. With respect to the objective criterion, again, in the Akiyazu trial judgment, it was held that a stable and permanent group include characteristics of automatic, non-voluntary and irremediable membership. However, the ICTR took those characteristics from the travaux preparatoires of the Genocide Convention, and those characteristics outlined there were those of homogeneity, cohesiveness, stability and tradition. And it is these characteristics that we submit to the court should apply objectively to the Videsh. With respect to stability and tradition, we know that the Videsh have had historical recognition within the state of Valeria. They have been recognised for hundreds of years, and they have their own cultural customs which may be considered tradition. With respect to cohesiveness, Defence Counsel submitted that they are not united. This is simply incorrect. We can see from the International Rights Watch report at paragraph 6 that in December 2015, the Videsh came together to peacefully protest the measures that were implemented against them by the Red Joy government. And furthermore, with respect to homogeneity, the group identify as being similar to one another. Gender is only defined generally as being either male or female, or neither, or a combination of both. However, the way they identify themselves, which leads me to the subjective criteria, is enough to demonstrate homogeneity. Turning to the subjective criteria and respect to the self-identification and identification by others. We do accept that there may be Videsh who identify as being third gender who do not go to live with their local Videsh community, and this can be seen by the use of the word often at paragraph 3 of the International Rights Watch report. However, those that do go and live with their local Videsh community identify themselves as being Videsh. More importantly, the Steelborn community identify the Videsh as being a distinct, stable and permanent group. The stillborn community have traditionally demonstrated animosity towards the Videsh. They have subjected them to historical pogroms over the years. When President Redjoy ran for election in November 2015, he ran political slogans blaming the Videsh for the economic ills of the country. And upon taking office, immediately implemented a series of measures that disenfranchised the Videsh, including confiscating their property and banning them from social services. Using this opportunity, the Dothraki Riders, a paramilitary group primarily comprised of stillborn community members, took this opportunity to align with the Redjoy government and began systematically attacking the Videsh, subjecting them to massacres, and by doing so, destroying 70% of the Videsh population. With respect to the subjective nature, to attack the Videsh is to attack the label Videsh. And the label Videsh is a combination of both gender and their ethnic characteristics. We accept that this court may not be satisfied on the information necessary before it, that the subjective criterion has been satisfied. However, it is our submission that the matter must proceed to trial, where Videsh and the surviving Videsh can come before this court and can testify to their ethnic characteristics. This is what happened in the ICTR in Akiyasu. When the Tutsis came to the trial chamber, they testified that they were an ethnic group. And at the pre-trial chamber stage of this proceedings, the Office of the Prosecutor, pursuant to Article 61, Paragraph 5, is only required to produce summary evidence, and that full evidence is to be presented at trial. Turning now to our second submission with respect to the Chamber's statement that Bannister's former status as an involuntary child soldier can have no effect on his culpability for the international criminal acts undertaken. Defence Counsel has submitted that there has been a legal error here. The only effect of legal error is that this Chamber may consider the matter afresh pursuant to Article 83, Paragraph 2 of this court statute. This court should independently find that the standard required to prevent a trial has not been met and displace the statement of the pre-trial chamber with a reworded finding that nonetheless rejects the applicability of any defence at the pre-trial chamber stage. It is our submission that Article 26, which Defence Counsel has submitted is a jurisdictional issue, is permitted. Bannister was 18 when he led the raiding parties. We accept that a couple of months prior, he may not have been brought before this court if he was still a 17-year-old. However, a bright line must be drawn, and the fact that he is 18 means that he is in the purview of this court's jurisdiction. Defence Counsel also submitted applicability of defences. Defence Counsel referenced Article 31, Paragraph 3, to which the Office of the Prosecutor has made submissions on, and I do not intend to discuss further, only to add that at Rule 80 of the Rules of Procedure and Evidence, a defence invoked under Article 31.3 is for the purview of the trial chamber. Defence Counsel has also discussed, the Office of the Prosecutor has also discussed the decision on the confirmation of charges heard before this court in 2016 with respect to Mr. Dominic Ongwim. And I only wish to add with that respect that at that case, the pre-trial chamber found that the Defence Counsel had submitted no evidence to negate even the low evidentiary standard applicable that the defence of duress should apply at the pre-trial chamber hearing. At paragraph 151, the pre-trial chamber went on to say that a trial is appropriate in order to also resolve this question. It is our submission that any defences are best addressed in two hearings. Either firstly, at the pre-trial chamber stage, in which evidence must be submitted to the level as addressed in Ongwim, or the trial chamber. We accept that a defence may apply in regards to Mr. Tarian Bannister. We do accept that he had an unfortunate upbringing and was an involuntary child soldier. However, no defence can apply at this stage of the proceedings, as Defence Counsel simply has not produced any evidence. Any evidence they have relied on is circumstantial, and they really must produce such evidence to demonstrate the applicability of either mental incapacity or duress. And just to touch on duress very briefly, Duress requires imminent threat to life. There is simply no evidence that Mr. Bannister's life was an imminent threat. Indoctrination had finished at the age of 15. There's a 3-year period in which he may have brought into the ideologies of the Dothraki riders. He also led one of the most brutal raiding parties that resulted in the dozens of massacres of the Videsh. There's just simply no evidence his life was an imminent threat. Turning now to our third and final submission with respect to jurisdiction, and that this court correctly determined it has the necessary jurisdiction to consider this matter. In this pleading, I'll be addressing 3 points. Firstly, that of democratic governance raised by Defence Counsel. Secondly, the test of effective control to which this court should apply. And thirdly, if there is any doubt and the court wanted to turn to the international community, that the United Nations would be the body to do so, and it will be our submission that it is not necessary for the court to turn to the UN. With respect to democratic governance, Defence Counsel submitted that a government seeks to exercise control over the hearts and minds of the people it seeks to represent. However, I wish to provide this court with a quote from Stephen Talman, who discusses democratic governance and legitimacy, from the 1999 journal article. And it states, and I quote, "If respect for human rights is to have any meaning in international law, an unrepresentative government who commits human rights violations on a massive scale, including genocide, forfeits its rights to represent the people and thus its status as government when it loses effective control." And here we have a democratically elected government who first of all disenfranchised its citizens and then failed to take any action when it was asked to or ordered to halt the actions of the Dothraki riders in committing massacres against the Videsh. President Redjoy then fled the state of Kurth, leaving it without a democratic government. Turning to the point of effective control, and we recognise the Office of the Prosecution has made submissions here that the test of effective control includes control over the territory, habitual obedience of the population, and expectation to permanency. Noting the time and given the Office of the Prosecution submissions, we largely adopt and support those submissions with respect to effective control, and simply remind this court that they have already determined that effective control is the relevant test to be applied, as outlined in the 2012 Egypt communication to the Office of the Prosecutor with respect to Egypt. And just briefly to distinguish, that 12-3 declaration was not accepted as it was made by a third-party representative who the Office of the Prosecutor did not recognise to be a head of state, Minister of Foreign Affairs, or someone acting in those roles. Thereby turning to our final point with respect to the any doubt that the court should wait for international law and the United Nations. And this simply comes from the fact that the United Nations have provisionally seated the state of Valeria and that there have been challenges to the credentials. It is our submission that the court need not wait for the UN to make a determination. This court has the necessary jurisdiction to consider this matter. The court is an independent judicial body as recognised by the preamble to the court statute, and also at Principle 2 of the Negotiated Relationship Agreement between the UN and the ICC, which recognises the court is an independent body. The court has already addressed the issue of jurisdiction in the decision on the confirmation of charges in Bemba Gombo in 2009 at paragraphs 23 to 24, where the court heard that pursuant to the customary international law principle, competence de la competence, the court has the necessary jurisdiction to consider this matter. And in summary, it is our submission that the pretrial chamber did not make any errors in its findings in September 2015. Your Honour, to go back to your question, I will ask my co-counsel to address that question in rebuttal with respect to victims' participation. And if I can be of no further assistance, that concludes primary submissions for victims.
Thank you. Well, each of the respective parties and the participants have raised quite important matters in their submissions. And what the Chamber will now do in the same sequence will be to give you the opportunity to respond, beginning with the Office of the, I beg your pardon, beginning with the Defense Counsel. You will each have, of course, 10 minutes.
Mr. President, Your Honours, I would like to address some brief points in rebuttal in response to the learned arguments raised by our learned friends for the prosecution and the victims' counsel. I propose to make one point relating to the first ground of appeal, namely on the arguing that at the time of the declaration, the military did not hold effective control, should Your Honours be minded to apply this test. 3 points on rebuttal for the second ground of appeal. Firstly, that the group identity of the Vidash and their protection under the Rome Statute under Article 7H. Secondly, relating to Mr. Bannister's specific intent and the modes of liability. And thirdly, addressing the relevance of the in dubio pro reo principle. And then I will conclude by making 1 point on the third issue in this appeal, Your Honours, namely the wording of the pre-trial chamber's decision. Proceeding to the first point of rebuttal, Your Honours. Our friends for the prosecution have suggested that legitimacy is ideal. Your Honours, we suggest that legitimacy is, in fact, not ideal. It is required. It's been suggested that the defence is arguing in favour of a democratic legitimacy test. However, I would like to clarify that the defence argument relates simply to the constitutionality of the government, Your Honours, be it democratic or otherwise. Our friends for the prosecution have sought to persuade Your Honours not to follow the examples of the Palestinian and Côte d'Ivoire declarations, or 12.3 declarations. They've characterised the Palestinian declaration as relating to statehood. I would like to simply clarify that in this particular instance, Your Honours, the second Palestinian declaration that was accepted effectively outlined a two-limb test. Is this entity submitting a state? And does the person submitting the declaration represent that state? It was after the United Nations had decided to recognise the statehood of Palestine that the declaration was accepted, Your Honours. And in relation to Côte d'Ivoire, Your Honours, there were also two declarations, both of which were accepted by the Office of the Prosecutor. In any case, the prosecution have sought to discredit the second declaration made because the first declaration was already in effect. However, the Office of the Prosecutor, in their communication on this, noted that jurisdiction was established pursuant both to the previous declaration and the subsequent letters as submitted by President Ouattara. Our learned friends for the prosecution have also suggested that international law does not require any form of government. We concur, Your Honours, this in fact is protected under the Montevideo Convention. We do not submit, again, that democratic legitimacy is required, simply constitutionality. And in fact, should Your Honours be minded to apply the effective control test, we do contest, in fact, that this interim administration exercises effective control. Your Honours, on this point, the relevant time to consider whether an entity or individual is competent to accept the court's jurisdiction is in fact at the time of filing, not at the time of the hearing. And Your Honours, this interlocutory appeal is corrective in nature. It is not a de novo hearing. Therefore, the court must consider the facts as they were at the time of the pre-trial chamber's decision. And the pre-trial chamber's decision, Your Honour, was based on the Office of the Prosecutor's determination, which was made at the time of filing. This was the case in the Egyptian declaration, Your Honours, where we see at paragraph 11 of the court's decision in relation to jurisdiction that the pre-trial chamber explicitly noted it had no power to review the Office of the Prosecutor, and the Office of the Prosecutor had made the determination based on facts at the time of filing. Your Honours, jurisdiction is absolute. It either exists from the outset or it does not. A manifest jurisdictional defect, such as the one in this case, the lack of legitimacy, or we also allege the lack of effective control, cannot be remedied by the subsequent passage of time. Your Honours, the aforementioned is particularly relevant because an Article 12.3 declaration gives this court retroactive jurisdiction, which is an exceptional circumstance, and therefore the test to establish jurisdiction should be stringently applied to the highest standards of accuracy. Your Honours, relating to the second ground for appeal, our friends for both the prosecution and the Victims' Counsel have conceded that the third gender people could, in fact, or the Vedash people could be considered as a gender group, but simply that they could be more than this. To quote our friends for the prosecution, the ethnicity was their primary categorization, and Your Honours, we contest that the principle of in dubio pro reo applies here, inasmuch as Mr. Bannister cannot be expected to have perceived or targeted this group as both an ethnicity and as a gender, and for charges of both genocide and crimes against humanity to proceed. Your Honours, I'd like to remind the court of the presumption of innocence, and pursuant to the principle of in dubio pro reo enshrined under Article 22.2 of the Rome Statute, in situations of ambiguity such as this, where it is unclear how one might be targeted, the benefit must go to the accused. Our friends have both sought to rely on the case of Kirstich before the ICTY, where the victims constituted both a national and a religious group. However, Your Honours, these are both categories of protected group under Article 6. In this case, gender is not protected under Article 6, and thus the benefit of the doubt must be given to Mr. Bannister. If anything, if they were targeted, they were targeted as a gender group under Article 7. But in any case, Your Honours, Article 7H, in relation to persecution, also protects other types of groups as a whole. Thus, the charge of crimes against humanity doesn't preclude this group of third gender people from being protected as a group, either as a gender group or as another type of group. And thus, Your Honours, this characterisation of the third gender people as a gender is undisputed, and therefore it cannot be reasonably established that there are substantial grounds to believe that they were targeted, Your Honours, or that they were perceived as an ethnicity. Your Honours, from this also flows our rebuttal in response to the suggestion that specific intent can be inferred from the facts. Again, if there are two particular groups in play, both protected under different articles, Your Honours, it cannot be inferred that Mr. Bannister, even if we apply the alternative standard suggested by our friends for the victims, that a simple knowledge of Mr. Sleet's intentions suffices. We cannot expect Mr. Bannister to have known that Mr. Sleet intended to target this group as either an ethnicity or a gender, Your Honours. It's simply not clear. And particularly in relation to the objective characteristics of the group raised by our friends for the Victims' Counsel, it was suggested that this group exhibits specific ties to the land, which are one of the cumulative criteria outlined in the Darfur case, Your Honours. And the likening was made with the Roma people. However, Your Honours, the Roma are typically not recognised on the basis of their typical links, their links to the land. They are recognised on the basis of their language, on the basis of their flag, and other characteristics, Your Honours, because there has not been an international criminal tribunal ruling on this issue, acting on applying the criteria post-Darfur, post-al-Bashir, Your Honours. And in fact, our learned friend suggested that the Defence Counsel was unable to establish that there were no specific links. And I would like to simply remind the court that we're not here to reverse the burden of proof to the accused, Your Honours. It squarely falls on the prosecution to establish this. Your Honours, finally, in relation to the third issue for appeal, our friends for the prosecution suggested that the court is not being asked to pronounce on the ultimate culpability of the accused. However, Your Honours, if this appeal chamber upholds the pre-trial chamber's finding, that is exactly what it is effectively doing, because the wording of the pre-trial chamber's finding was that Mr. Bannister's experiences could have no effect on his culpability. This precludes him from leading evidence relating to his experiences in furtherance of any Article 31.1 defences, particularly shuts down his effective 31.3 defence, which we concede would best be presented at trial, but also precludes any mitigating factors at the sentencing level from relating to this experience. Your Honours, our friends for the prosecution have conceded that, in fact, that this appeal should be granted on limited grounds. We would welcome that, Your Honours. We note that from paragraph 151 of the ongoing pre-trial chamber hearing, clear evidence could be adduced to, in fact, lead to a non-confirmation of the charges. And we would, in fact, welcome and encourage Your Honours to consider, in fact, by virtue of Article 31.2, 31(1) defences might operate concurrently. This was part of my submissions. But in any case, we would be happy to lead a 31(3) defence in the event that this does proceed to trial. And if I might conclude, as I'm mindful of my time, Your Honours, Defence Counsel would like to might I have a moment to conclude, Your Honours?
The rules will permit you to have 1 more minute.
Thank you, Your Honours. Defence Counsel invites the court to view this case as an opportunity to resolve a series of live issues with an authoritative appeals chamber decision. In relation to the first issue, it can be made clear that the applicable test is the legitimacy one, not effective control, and that this reflects recent custom, not the custom as enshrined in a 1923 arbitration. On the second ground, this court has the opportunity to strike a delicate balance between protecting the rights of a minority group under Article 7, but upholding the strict definition of genocide and ensuring fair trial rights for the accused. And in relation to the third appeal grounds, Your Honours, it can clarify for once and for all exactly how Article 31(2) should be applied and how Article 31(3) should be applied. And unless I can be of any further assistance to the court, this concludes the defence rebuttal at this time.
Thank you, Counsel. Let me hear now from the Office of the Prosecutor.
Mr. President, Your Honours, I will make 4 points in response. Turning to the first point in response, counsel for the defense have argued that the test is not democratic legitimacy, the test is not effective control, but rather the test is of constitutionality. But Your Honours, state practice is conclusively against this test of constitutionality, because this test will be illogical in a world where every government in our world today draws reference or is originated from some form of revolution. If we are to take the Defense Counsel's test to its logical conclusion, America, the government of America, would not be able to represent the country of America because of the American Revolution. Germany would not be able, the government of Germany would not be able to represent the state of Germany because they overthrew the Nazi German regime. And therefore, on this basis, we say that constitutionality cannot be the test. It is totally illogical. Now, turning then to the second point in response, this relates to their reliance on the Côte d'Ivoire authorization decision. Now, they themselves have considered that it was not a 12-3 declaration. They were letters. And further to this, it would be illogical to suggest that we will need a further 12-3 declaration because already at the time where the original government filed the declaration, this declaration was not temporally limited. Laurent Gbagbo filed the declaration in 2003, and therefore the 2010 letters and the 2011 letters do not have any legal significance, and this was noted by the court in the quote we had mentioned earlier. Now, turning then to the third point in response, we know that counsel for the defense has invoked Article 22(2), the in dubio pro reo provisions. But Your Honours, as this court made clear in its Lubanga decision, interpretation of the law must be distinguished from creation of the law. The former is allowed, whereas the latter is prevented by the in dubio pro reo principle. And here, we are not proposing a new category of groups, or rather we are not proposing that ethnicity be expanded beyond the categories in which it was originally envisioned. Rather, we are basing the definition of ethnicities from the decided cases of the jurisprudence of the ad hoc tribunals, as well as the jurisprudence of this court, as found in El-Bashir, Badanin, and the Akeyesu decision. Moreover, Your Honours, this court in its Katanga 2014 trial decision made clear that because the Rome Statute is a treaty, the principles of interpretation enshrined in Vienna Convention of the Law of Treaties do apply before the in dubio pro reo principle applies. Turning then to the last point in Sir rebuttal. Now, this pertains to counsel for the defense's suggestion that the pretrial chamber is completely foreclosing the possibility of defenses even at trial. Now, even if this is the proper interpretation to take of the pretrial chamber's decision, We do agree that the defense should not be precluded entirely, but Your Honours, the appeal should only be allowed on the very limited ground that the defences should be able to be invoked at trial. However, the rest of the pretrial chamber's decision should be affirmed as regarding the confirmation of charges, because the confirmation of charges is not materially affected by any error pointed out by the counsel for the defense. And the court can do this pursuant to Rule 158, Part 1 of the Rules of Procedure and Evidence of this court. Your Honours, this concludes my responses, unless I may be of further assistance.
Thank you, Counsel.
Thank you. May it please the court.
Yes. The legal representative for the victims, do you wish to make any to address by way of reply?
Yes, Your Honour, we do. Your Honour, the legal counsel for the victims draws 3 points of contention with the cases of the case of the defence. However, first, to answer Your Honour's question that was directed at my learned co-counsel, and that was whether the standard applied by the pretrial chamber regarding the classification of the verdict was in fact the correct standard. The standard applied by the pretrial chamber was stability and permanence, and we accept that this was relevant but not entirely complete as the standard, and so not entirely correct. But, as my learned co-counsel put it, a legal or procedural error may be amended or considered afresh if it materially affects the reliability of the trial, derived from Article 83, Paragraph 2 of this court's statute. And as the arguments put forward by both the prosecution and the victims' counsel, we submit apply the correct test of ethnicity. We submit that independently of the pretrial chamber, this appeals chamber can determine that the Verdesh are a protected group because they are an ethnicity. This brings me to our first point of contention, which is the statements by the defence, in the case of the defence, that they may be objectively considered a gender and subjectively considered a gender and nothing else. The clearest example of this, Your Honours, came in the rebuttal, where the defence stated that a group that might have multiple identities, the fact that a group might have multiple identities creates doubt that should be interpreted in dubio pro reo. But it was clear in the Krstić decision that Bosnian Muslims, despite having multiple characteristics, being ethnicity, being a national group, and being a religion, still fell clearly within the definition of genocide. The Victims' Counsel submits that just because a situation is complicated does not mean that it is unclear, creating a lack of clarity that should be interpreted in dubio pro reo. To that end, we submit that the Verdesh are identified on the basis of ethnic characteristics as well as being identified on the basis of gender characteristics. At paragraph 4, the International Rights Watch report states that not all people who are identified as being third gender around the time of puberty are sent to live with the Verdesh community and become Verdesh. This presumably means that not all people who have third gender traits become Verdesh. If there is such a thing as a person who is third gender but not Verdesh, then Verdesh must be something more than simply a person who is third gender. Targeting under the Verdesh banner must also be targeting on the basis of their other traits. The other traits that we see in the International Rights Watch report are language, culture, and a different relationship to the land in terms of being nomadic and living outside communities, much like the Roma communities, the Roma people, who are recognized as an ethnicity within the majority of Europe. For that reason, we submit that they are identified both as a gender and as an ethnicity. Of course, the targeting of the Verdesh on the basis of gender is not a genocide, but the targeting of the Verdesh on the basis of an ethnicity is. As both have occurred, Tarian Bannister, we submit, should be committed to stand trial for his targeting on the basis of an ethnicity, and for that reason the charge should be confirmed. Turning to our second point of contention, and this is the jurisdictional argument raised by the defence that only those governments that are constitutionally legitimate may bind the state in international law for the purposes of an Article 12.3 declaration. The key logical problem to this is that we do not have a constitution before us. There is nothing stating in the International Rights Watch report, nor the factual matrix, that Valeria in fact has a constitution. and so any argument founded upon constitutional legitimacy defies logic in this courtroom. In any event, even in constitutional governments, like in Fiji, it was acknowledged in the case of Prasad against Fiji in 2001 that if necessary, and there was no rival government that was clearly willing to resume power, a coup d'etat would be recognized as domestically legitimate if it had effective control. That was not the case in Fiji, as the ousted president before the hearing stated that he would be willing to return to office. But in this case, there is no indication from the Rejoy government, the government in exile, that they would be willing to resume office or that they are actively seeking office. Which brings us to the examples raised by the defense of cases where only those that are democratically legitimate or constitutionally legitimate would be lawful and capable of binding the state. These were Cote d'Ivoire, Sierra Leone, Haiti, and Yemen. In all of those cases, one factor was present. The government in exile was actively seeking to return to power and actively seeking a return to office. If we look at the myriad of other cases where the legitimacy of a government has been in question briefly and then recognized by the international community, which we submit represents state practice and opinio juris, such as Thailand in 2006 and 2014 and Pakistan in 1999, the same can be found. That in Thailand and Pakistan, though there was clearly a coup d'etat that was not constitutionally legitimate, that did not represent democracy, and did not represent popular sovereignty or any popular will, because in all three cases, the government ousted had won a landslide victory. Any matter other than effective control was never considered by the United Nations, because the government in exile had never submitted a competing delegation. Here, we find that the Valerian military regime has not submitted a competing delegation. Even if the challenges to the legitimacy of the current Valerian military regime were accepted by this court as being a challenge, these were made by third party states like Corte and other trading partners. Within Stefan Talman's articles and his book chapter on the legitimacy of governments in exile, he stated that a government in exile will only be legitimate where it is politically independent, and this is in fact represented in the state practice as well. Your Honours, if the only challenge to legitimacy and the only groups seeking to prop up the Rejoy government are third-party states, it cannot be reasonably said that the Rejoy government is politically independent, and for that reason, Your Honours, cannot be a legitimate government in exile. The consequence of this is that for practical purposes, there must be a government capable of binding the state in international law, as all states have the capacity to enter into treaties, as is acknowledged in the Vienna Convention on the Law of Treaties. The only exception to this occurred in Somalia, where there was simply no government to choose from, and that is clearly distinguished here, as there are two. For that reason, Your Honour, the test that should be applied is the test of effective control, which is the only test that has been applied where there has been no competing delegation actively seeking a return to power. Finally, Your Honours, turning to the third point of contention. And this was on the basis of pleading 3. Now, there were 2 points raised by the defence that the Victims' Counsel takes issue with. First was the reference to the specific wording of the pretrial chamber, and that this was in error because it related to culpability and precluded the possibility of defences being raised later at trial. However, as was held explicitly in the Lubanga and Katanga confirmation decisions before the ICC, Your Honours, the decisions of the pretrial chamber are not binding on the trial chamber, except in one aspect, and that is the decision of whether or not to confirm the charge. Your Honours, the Victims' Counsel may accept that the wording of the pretrial chamber's statement may have gone one step too far by considering culpability, which relates to guilt or innocence. But that is not the issue here. The issue for this court is whether or not the matter may proceed to trial or not. As far as that issue is concerned, Your Honours, this court may reword the decision of the pretrial chamber if they deem it necessary, pursuant to Article 83, paragraph 2. but the conclusion reached as to whether or not this should progress is the same, because there is simply no evidence put forward to support claims of duress, mental incapacity, or any of the other forms of defence within Article 31, Paragraph 1. Our second point in relation to pleading 3 and duress is a logical rather than legal point. The prosecution and Victims' Counsel in primary submissions addressed that there was no evidence that Taryn Bannister was still under continuing threat. And so I will deal with the second two elements of duress. That is, that he acted reasonably and necessarily, and second, that he did not seek to do greater harm than the threat that was put against him. But, Your Honours, his raids were identified as among the most brutal. This logically suggests that he went above and beyond what was expected of other leaders, and presumably went above and beyond what was expected of him, the minimum standard that would be required to avoid... Your Honours, may I have 1 minute to conclude?
Yes, proceed.
Thank you, Your Honour. He went above and beyond the minimum standard required to prevent his own punishment, meaning that it was not necessary, it was not reasonable, and he did seek to cause greater harm than the threat put against him. Your Honours, none of the issues here present a legal impediment to moving forward to the next phase, that is trial, and thus this court should move forward to trial and towards a more just world. If it may please the court, that will conclude submissions for the Victims' Counsel.
Thank you. Well, participants, counsel for the defense, the office of the prosecutor, and the legal representative for the victims. This brings to an end the hearing stage. I should quickly tell you that as I look to the objective of this competition, and as I looked at Article 4, which has the rubric aim of the competition, I think that the objective has by far been exceeded, and I can quickly read. The competition aims to encourage university students to improve their knowledge of international criminal law in practice and in particular of the ICC, its mandate and its jurisprudence, by simulating ICC proceedings through arguing a hypothetical case. And in so doing, it seeks to enhance the knowledge of the Rome Statute and so on. I have to say, speaking for myself, that even before we go to deliberate, the standard has been quite impressive. And I think you have given us a very difficult job in our deliberations as we retire. So, for each of the competing teams, the defense, OTP, LRV, even before we come back, you have all been impressive in this, what really has to be a final, because the quality has been that impressive. All right, so having said that, the bench will now leave the courtroom to proceed to deliberate in chambers. You will be allowed to leave the courtroom, but in any event, you should be back by 16:15, by 4:15. Thank you very much.
All rise. All rise. The International Criminal Court Moot Court Competition of 2017, the English version, is now in session. Please be seated.
Right. Well, this is the final moment. This has really been, I have to say, an extremely spirited deliberations, as we had to grapple with what really was a difficult result. Suffice it to say that the final result distinguishing the winners of the competition and those who came second, as will be transparently seen, is razor thin. And not only is it razor thin, but there was actually a majority. So it's that close, and it's that the quality was that good. The impressive quality from the defense, the OTP, the LRV has to be a reward for your hard work, your research, and no doubt has to be as a result of your good coaches who also would have helped you, and your universities. Now, according to the rules of the ICC Moot Competition, deliberations were made to assess each of the participating teams based on the following criteria. 1, organization, structure, and analysis of the issues. 2, use of facts and legal principles. 3, the use of authorities and citations. 4, your persuasiveness, how ingenious your arguments were, the logic and the reasoning. And finally, the presentation. And we, of course, scored you on that basis. But before we come to that, perhaps we can just offer some comments. And we will do it in the same sequence by which we received the arguments. The defense, the clarity of your submissions, I found impressive. You set out what you proposed to achieve at the outset of your submissions, and you went about methodically doing just what you said you would do. By your obvious research, you demonstrated not only depth of understanding, but also there was breadth. You fielded a very difficult question from my colleague on the left, like the legitimacy of elected governments, and you avoid for a moment. But if I may mix metaphors, you landed easily on it, and you did well. You demonstrated a firm grasp of the jurisprudence, and you used it persuasively. The OTP, all the teams quite. You were also quite impressive. Again, your use of facts and legal principles, they were robust. Former prosecutor in my earlier life, I found it extremely refreshing that you were able to confront the weaknesses in your case head on, grasp them and deal with them as you should. And that was quite good. You were able to, I'm just quickly going to run through the points because I appreciate we're running a bit late. You were able to weave through your submissions the questions that my colleague on the left had raised, and you were able to incorporate it effectively as part of your submissions. You were able to handle the question that was thrown at you also quite well, demonstrating that you were quite familiar with the material that you had to deal with. The LRV, You also had demonstrated a good appreciation of the issue, and you demonstrated that this was an appeal and that the chamber should be correctly focusing on what was the purpose of the hearing. You were able to quite well understand the legal principles that turned on ultimately your client, on Article 6. Your arguments were innovative, they were relevant, and they answered the question. So those are the general observations. So I will leave it at that. I don't know if you want to add anything, Gerard?
Since we don't have much time, actually virtually no time, just to congratulate all. It was, as Judge Henderson has just mentioned, it was a very tight race, if I may call it, between the three teams. So congratulations.
I can only but agree with what has just been said. I really, really appreciated all rebuttals. They were great, to the point. So congratulations to all of you.
I beg your pardon. Yes. The teams were marked individually, and then we looked at the notes. Two were quite close and awarded the same result. One was quite close, but one became two, and two became one. It was that close. And three was a close third. So I say that if only to underscore the point that there's no shame in any result here. Much the same way that in an Olympic final, you are one of the creme de la creme, even if you have a bronze medal. It was that almost Usain Bolt close. All right, so having said that, I will leave it to my colleague, Mr. St. Michel, who will announce the second runner-up for this final.
Thank you, Mr. President. So again, to reiterate my congratulations to all of you. And the second runner-up of this ICC Moot Court Competition 2017 English edition is the Legal Counsel for Victims.
My colleague will now announce the result of the team that came, who's the first runner-up, this team is separated by a mere 3 points when we did an aggregate of the respective scores. So Mr. Abtahi will announce the first runner-up.
So the first runner-up of this ICC Moot Court Competition 2017, the English edition, is the Office of the Prosecutor.
It follows that the winner, of course, of the ICC Moot Competition for the year 2017 English edition is the office, I beg your pardon, is the Counsel for the Defense. Congratulations. The judges in this final were invited to also consider the issue of the best oralist, but having regard to the score that was awarded during the earlier stages, which remains intact, the best oralist for the ICC Moot Competition 27 English edition is Ms. Samantha Ann Turthdas from, I think, one of the universities who's not in this team. Yeah? Okay, so that brings to an end the formal part of the competition. I really want to congratulate each of the teams. It was really difficult. There's no disgrace for any of the teams, and I say so with utmost sincerity. Your preparation for each team was impressive. Your grasp of the law, the jurisprudence, and how you were able to use it clearly demonstrates that not only do you understand the principles, but that the future of the international criminal justice and its practice and procedure is in good hands when the baton is passed on to each and every one of you. All right, so at this stage, I would now want to again thank you, congratulate you for your excellent work, and I am now happy to invite all of you to a reception in the lounge area of what we call the conference cluster, and the ICC staff will escort you happily, where we will see in a few minutes once again. Thank you very, very much.
all rise.